Oh, come on. They charge him with theft because he's trying to charge his phone.
No, they didn't charge him with that, Your Honor. This is the...
I know, but that's the contact to get to him.
Imagine getting arrested and charged with theft for trying to charge your cell phone outside of a 7-Eleven. Sounds wild, right? Well, that's exactly what happened in this incredible court case we're breaking down today. Today we're diving into a fascinating transcript featuring a judge's sharp questioning of police tactics and charges. Our defendant, Samuel Woto, or sometimes referred to as Doto, found himself in custody with two charges: theft of a service and failure to identify. The core of this controversy, the initial police context stemming from him charging his phone in an alley. We'll explore the legal arguments, the judge's skepticism, and the eventual outcome of this unusual case alongside another plea deal for another defendant, Mr. Riviera.
Hi, Alan. Tell me what's up.
If we can get PC for Samuel.
Okay.
I want to see if we can get PC for Samuel Duto.
Okay, sure.
You're on September 13th.
Okay, hold on. Just way too loud. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases. He got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
Okay.
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven, the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and asked for his identification. The suspected charge is theft of a service under Penal Code.
Come on, they charge him with theft because he's trying to charge his phone.
Here we immediately see the judge's incredulity. The prosecutor's initial statement implies the theft of service charge is the reason for the contact, but then clarifies it's merely how they get to him. This exchange highlights a critical legal concept: probable cause. For an arrest to be lawful under the Fourth Amendment of the U.S. Constitution, officers must have probable cause to believe that a crime has been committed. The judge is clearly questioning if simply charging a phone without explicit prohibition from the business owner constitutes theft of services under California Penal Code Section 498. This statute typically applies to things like evading payment for public transportation, restaurant tabs, or utility services with intent to defraud. Merely plugging into an exterior outlet without more often doesn't meet the high bar of intent to defraud or a clear service for which payment is expected in that context. The judge's skepticism is about whether the initial stop and the subsequent charges had a legitimate legal basis, rather than just a pretext to investigate further.
No, they didn't charge him with that, Your Honor. This is the...
I know, but that's the contact to get to him.
Yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so what? So they go up to him, they start talking to him.
He identifies himself as Vinny Mancuso, birthday 3/19/1991, and he stated his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Woto.
This is where the second charge, failure to identify, comes into play. The officer's report indicates the defendant provided inconsistent identification. In California, falsely identifying oneself to a police officer can be a misdemeanor under Penal Code Section 148.9. However, it's crucial to understand the context of the initial contact. If the initial stop for charging his phone lacked probable cause, then any subsequent evidence or charges derived from that unlawful stop could be subject to the fruit of the poisonous tree doctrine, potentially leading to suppression. Officers generally cannot compel identification without a reasonable suspicion that a crime has occurred or is about to occur. If the judge believes the theft of service was a baseless charge, then the request for ID and subsequent issues with identification become legally suspect.
They were doing nothing.
The defendant had outstanding warrants and was placed in custody.
He was
He was charging his phone.
What do you think? charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on. Do we need help back there?
It's like an adult, and I can treat you better.
You all right back there?
Yeah, he's fine. He's just upset because he wants to go now. Yeah, he's not getting his way.
Who is it?
I don't even know him. The attorney told him he was done, but I don't know about it.
Okay.
Tyler, probably. No, it's not. Let me see.
Talk to Pavel, let's see.
Judge, we'll defer to the court. I mean, he didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good. He's not going anywhere, right, on the theft. So.
When he's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest. I mean, that's.
Do you want to do something with it today anyways?
This exchange between the judge and the attorney reveals the underlying leverage in many plea negotiations. The judge is trying to clarify the true reason for the defendant's continued custody. The attorney, speaking for the prosecution, seems to be arguing that even if the failure to identify charge is shaky, the defendant had outstanding warrants, which would keep him in custody regardless. However, the attorney also implies the theft charge is good, despite the judge's previous skepticism. This tactic is often used to compel a plea, as a defendant with a warrant or a good charge has less incentive to fight other charges, especially if they can get time served. This highlights the practical realities of the court system, where expediency often influences outcomes, and defendants might feel pressured to accept a deal on questionable charges to avoid prolonged incarceration.
We had something worked out. I didn't like the fact that.
Because it might happen anyways.
I
You know
wanted
what I
time
mean?
served. I wanted the time served. He offered, he would have to do 24 more days.
I'm okay with that, or I'm okay with whatever you want.
Okay.
It's up to you guys.
Yes, Your Honor, I'll always refer to Pavel with things that, after 90 days, depends once the time served.
Yes.
Okay, and I'm totally fine with that too.
Okay, thank you. All right.
Thank you.
We'll get him out. Thank you.
Later that day.
Alan. Okay, so first we have, is this that's
Rivera.
Rivera and Soto?
Doctor, with the D.
Oh,
I can't-
Duarte,
I know
right.
I mispronounced it, so. Pronounce it one more time.
Duto.
Yuto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with 2 cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the.
Dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it, you know?
This is the moment the plea bargain is revealed, and the judge acknowledges it as a fantastic deal. The prosecution has agreed to dismiss the theft charge and proceed only on the failure to identify. From the defendant's perspective, this is a significant win. A theft conviction, even for a misdemeanor, carries a stigma and can have long-term consequences, impacting employment, housing, and even immigration status. The judge emphasizes this, noting how a theft case can host someone, potentially leading to felony charges in the future if they reoffend due to strike laws or enhanced penalties for repeat offenders. By dismissing the theft charge, the defendant avoids those more severe potential ramifications, even if they still face a misdemeanor conviction for failing to identify.
Most times people plead to the theft case and it really hoses them, because then you're looking at, you know, federal, or not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served. What time are we looking at? No, Roy Duato.
Oh, 18/6.
18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering these agreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this.
Here, the judge meticulously outlines the constitutional rights both Samuel Wodo and Mr. Riviera are waiving by accepting their respective plea agreements. These are fundamental rights guaranteed by the 5th and 6th Amendments of the U.S. Constitution, including the right to a jury trial, the right to confront witnesses, and the right to present a defense. This ensures the defendants understand the gravity of their decision. Furthermore, the judge correctly warns about potential immigration consequences for non-citizens. Depending on the specific charge, even a misdemeanor conviction can lead to deportation, inadmissibility, or denial of naturalization. This collateral consequence warning is a crucial part of due process, as defendants must be fully aware of all the implications of their plea before entering into it.
Now, Mr. Rivera, you're charged with assault of a family member. You need to understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you'll be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Have you ever been to prison before? It's not a fun place, man. You can never own a gun or ammunition as a result of this plea bargain agreement as well. You picking up a gun is a Class A misdemeanor in and of itself, okay? What time are we looking at on Rivera? 21/7? Okay, so it's 21 days in jail. Credit for the 7 days that you've already done. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your court costs so you won't owe anything, and good luck to you guys.
This transcript offers a fascinating glimpse into the mechanics of plea bargaining and a judge's role in scrutinizing charges. For Samuel Wodo, the case concluded with a plea agreement where the more serious theft of service charge was dismissed. He pleaded guilty to failure to identify and was sentenced to 18 days in jail with credit for the 6 days that he had already served, essentially resulting in time served. For Mr. Riviera, who was facing an assault of a family member charge, he also accepted a plea agreement. He pleaded guilty to the offense, receiving a sentence of 21 days in jail with credit for 7 days served, also resulting in time served. The judge made an affirmative finding of family violence, warning Riviera of enhanced penalties for future similar offenses, including potential third-degree felony charges and minimum prison sentences. Both defendants had their court costs waived, making the end of these particular cases in this court session. Thanks so much for sticking around to the end. Make sure you hit like and subscribe for more courtroom drama.